Today we start with a very important question which every law student at the outset of the course asks oneself. That is the question, what is law? Law is a very difficult concept to understand as it is not defined fixedly or rigidly. Law is an open-ended concept. Customs, conventions, statutes, acts, ordinances, bylaws, everything comes within the purview of law. Now, if we make laws defined and rigid, in that case, the difficulty will be the law will not be flexible and dynamic, and it will not be able to expand and take in the changing concepts and demands of the times and the society. Therefore, law is to be understood as an open-ended concept. Why do we need a law? We need a law to build an orderly, just, equitable, fair society which runs on rule of law. What is rule of law? Rule of law is the importance, the basis on which the society runs. It is respect for the elements of law such as justice, equality, fairness, dynamism, so on and so forth. Therefore, law is a very important element of society building, of government building, of nation building. Law is a very dynamic concept. So, in a society rather, cannot function without the foundation of law. A society is built on the foundation of law. As you are aware that in a society there are always conflicts of interest. There is a push and pull syndrome. Now, to resolve this tension between the push and the pull and the conflict of interest, law plays a very important role in resolving these conflicts and take the society forward and build the nation. This is the basic idea of law. It is very wide in its concept. Article 13 of the Constitution of India tells us that law is those laws which were promulgated before we became independent and which has been accepted as such as laws. Laws are those laws which are promulgated after the independence by the parliament or the legislative assembly and has the force of law. And laws are those customs and conventions which have the force of law. Now, as a student of law, you must understand what is law in force and what is customs and conventions which has got the force of law. Now, those customs and conventions which the people accept as a part of law and which cannot be avoided and which has been in existence for a long time, which is called antiquity, which is there for continuous period, it's called continuity, whose content is very certain, it is called certainty, and they should not be against public policy. Now, these customs, which is accepted as such, they are also part of the law. And those laws which are promulgated by the Parliament and the Legislative Assembly and has been approved and signed by the President and the Governor respectively, they are also law in force. So we have to understand and distinguish between law in force and customs and conventions having the force of law. The next very important question that comes in mind is, should moral be a part of law? Now, just imagine if you have a set of laws which do not have moral in it, what would happen? The law would become exploitative and oppressive, right? Now, to make the law accountable and to make the law self-auditing, we have certain mechanism. And one such mechanism is to have certain moral values into the law, inculcate certain moral values into the law. Take, for example, if there was a law for which you did not have a judicial review, or if there was a law which did not take into account the elements of natural justice, how draconian the law would be, and it would not take into account your requirements, your supports, your human values, and then it would be very, very oppressive, very, very exploitative. Therefore, law must contain certain moral elements. Now, these moral elements, some of them are universal, such as equality is universal, justice is universal, liberty is universal, but the content of liberty, justice, equality may vary from time to time, society to society. Take, for example, 50 to 60 years from today, we were not talking about LGBTQ community. We were not talking about their human rights, and they were an invisible, exploited lot relegated into the darkness of the society. But today we think it is a very important aspect of society that we bring them to the forefront and honor their human rights. This is the changing value. The values within the concept, the universal concept of equality, liberty, justice has changed. But the concept itself, equality, liberty, justice, does not change. This is the moral which is within the, inculcated within the law. Without these morals, law would become draconian. Another example would be Article 32, Judicial Review, where you feel that the law is violating your fundamental right, or your fundamental right has not been taken care of by the state. Article 32 helps you to go to the Supreme Court or the High Court and appeal before them, plead before them that your fundamental right has been violated. Now, these violations of fundamental right can be very oppressive. Now, a law which is without these elements of judicial review will be exploitative in nature. Therefore, it is very important to have certain moral aspects in the form of universal values such as justice, equality, and liberty within the concept of law. Now, law can be divided and classified in various forms. One such classification is law can be civil and criminal. Now, under the civil nature, we also have the revenue laws and the business laws. And the criminal nature has certain minor criminal laws and major laws in the form of Indian Penal Code and Criminal Procedure Code and the Evidence Act. Now remember, Evidence Act is applicable to the civil side also. When you take evidence, it has to be in accordance with as it is laid down in the Evidence Act. The other classification of law is private law and public law. When I'm talking about public law, I'm talking about constitution, criminal law, etc. Under the private law, we have a unique situation where the state confers us with the power of deciding our status. Take, for example, the contract law. There you are making an offer, somebody is accepting your offer. So you become the offerer and the person who accepts your offer becomes the acceptor. Now you have changed your status and you are taking your business forward. So this is a private area of the law. Tort is another aspect of the law which can be taken both in the public side as well as in the private side. When I take it in the public side, I take it to defamation, I take it to public nuisance. When I take it to the private side, I take it for private nuisance. I also take it for trespass. Battery and assault can be both in the public side and the private side. Now, in these areas, we call it right in personam and right in rem. Those rights which is against the whole world as such, they are right in rem. And those rights which is against a person, they are called right in personam. This is the privity of law. The other aspect, classification of law is that law can be international and national. National law is also known as municipal law. The other one is international law. And within this international law also there is a bifurcation of public law and private law. The public law is, say, a situation during the war, situations of neutrality, situations of nationality, recognition, all these are public aspects. But there are certain private aspects in international law. This you must understand that as our secular activities have expanded, people are going from one place to another place. They buy property, they get into marriage, they might adopt, they may enter into contract, they might commit a tort. All of these activities are regulated by private international law. Now, private international law is a process, it is not a substantive law. This process of law tells us which is the jurisdiction of the court and where and how we should file our cases. Which law will apply to us when we file our cases. So these aspects are looked into by the private international law. In the public international law, we have focused on human rights, we have focused on civil rights, we have focused on settlement of dispute between countries. We try to find out the status of a country if the country decides to stay neutral in a situation of war. We also try to find out how to handle belligerency and insurgency and how it impacts on the international platform. Another aspect of international law, which is we will be discussing in a later module, is the function of the United States and how the United States itself has developed and evolved a set of norms which has taken the form of law, which we cannot say is promulgated by a sovereign. Now, there are certain schools of law which try to explain what the law should be and how the law should function. So, there are functional aspects of law, there are definitional aspects of law. Now, I would like to start with the school of natural thinking. Natural law is the first element of law which try to give us these universal values of equality, liberty, justice, etc. Now, we derive this natural law from certain a priori phenomena. When I'm saying a priori phenomena, I'm saying that reason is natural, and with the help of this reason, we have derived certain morals, certain aspects from the nature itself, and then developed into a principle of law. This is the transition from the a priori is to the ought of the law. Now, this natural law by itself has not been able to focus on certain very important issues of secular activities, etc. It has not been able to tell us how to control and regulate the power of the sovereign and prevent the sovereign from being oppressive and from being exploitative. And in this aspect, the natural law did not have a definite answer, definite way to show the people how to control the sovereign. When we discuss natural law, we'll definitely come to address many other issues which is within the concept of natural law. But the failure of natural law to answer certain issues of controlling and regulating the sovereign and also regulating the secular activity of human being led to the decline of natural law, and we began to think that we should have a law which must be very specific. Now, this is also a is of the positive law, which says the law promulgated by the sovereign is, again, quote unquote, is the law. Now, this law is different from the a priori is. The concept of a priori is your reason which is deriving certain values from the natural phenomena which is around you. And the is in the positive law is a law that is promulgated by the sovereign. Now, this is stated to be the command of the sovereign by Austin. And Bentham says that when a law is promulgated by the sovereign, it must have utility, meaning that it must have maximum utility or maximum happiness, maximum usefulness for the maximum number of people. Thereby, when you are promulgating the law as a sovereign, you have to first assess whether the law that you are promulgating is for the benefit of a large number of people and not for the benefit of a small minority group of people. Now, this is very important. If you make the law only for the benefit of the minority, then it will become discriminatory. But equality among equals is fine. But equality among unequals is not fine. It's unfair. It's not justice. Therefore, it's a beautiful phenomena that India has developed something called positive discrimination or affirmative action, where those people who are in minority and are not able to keep up with the majority of the people, in that case we have to give them certain elevation, a little lift, so that they can come at par with the other group. Now, this mechanism of giving a slight lift to the people who are lagging behind, who have not been able to catch up with the forward-going population, this is known as affirmative action. So now, the beauty of legislative framework as thought of by Bentham and Austin are very significant. A, you have to make law which is for the benefit for the large majority of the people, fine. But there is a section of people who are not able to take advantage of that law. So they are in a painful situation. Now we have to give them a little push and bring them at par with the majority of the people so that they are also able to take advantage of the law that has been promulgated by the sovereign. So this is known as affirmative action, or this is also known as the positive discrimination for the upliftment and benefit of the people. Both Bentham and Austin, they were of the opinion that since natural law failed to answer some of the questions of secular activity and control of the sovereign, law should be without moral. And for some time this experiment took place, and what was the result is known today as mercantilism, where people were only looking for profit. Slave trade, trafficking, trading in women, trading in arms, trading in drugs, everything was legit, everything was valid. Now people realized that unless we had certain elements of moral inside law, then mercantilism would be extremely exploitative, extremely anti-human rights. And this was evident during the World Wars I and World War II. It was at this juncture that people began to rethink about having morals in law. Therefore, it was a stage of revival of natural law and bringing back certain moral values into the law again. But before I go into the revival of the natural law, I'd like to share two things with you, two thinkers rather with you. One of them is Kelsen. Kelsen said, if we eliminate all the other superficial and non-law matters from law, such as history, economics, sociology, politics, and take only the law, then it becomes pure law. And he named his theory the pure theory of law. In this, he is saying law is a triangular structure with on top the ultimate norm that he calls the Grundnorm, and each lower norm finds validity from the higher norm, and it goes on and on and on, and ultimately the entire system is validated. Now, validated by whom and how? And interestingly, he says validated by a transcendental metaphysical norm. And this transcendental metaphysical norm can be equated by the values inculcated by the natural law in the form of equality, justice, and liberty. Therefore, at the end of the hierarchy of norms, we find he's talking about a transcendental metaphysical values, which will render validity to the hierarchy of norms. The other very interesting thinker is Savigny. He says law grows like language. And why does he say it? After the French Revolution, there was a dilemma, whether we should have the monarchy. Monarchy was exploitative. People threw the monarchy out. They wanted a secular government, but the secular government proved unstable and corrupt. It did not meet the expectation of the people. And therefore, people like Savigny, Pukta, and Henry Mann, I should not forget that, they came up with the idea that law grows like language. Henry Mann said law is the product of long-standing customs. And he says it is a transition from, it's a result of experience, and it is a transition from status to contract, which is very true. We are today in the market-driven economy where every relationship is largely dependent on some kind of contract or another. And Savigny says law grows like language, unawares, unconscious, but its growth is to meet the requirement. Now look at you. The language I used to speak is very similar to the Shakespearean language, but the language you speak today in the WhatsApp or in your message group or in your social media is strange language to me. It is not British English, it is not USA English, it is not Australian English, but it's a new kind of English which you have developed, and nonetheless the language is valid. Similarly, depending on the demands of the society, depending on the requirement of the society and the nation's cultural growth, cultural values, cultural norms, the law shapes itself, grows itself. And Savigny says that law is, the primary society also had law. Now, what is this primary society? At the beginning of civilization, the society we had, even that had certain kind of norms. They did not have any forum. They had no written norms, but there was a kind of mechanism by which people would adhere to what was decided to be the norm of the time or norm of the clan or norm of the tribe. So there was a mechanism. In the secondary society, we started forming the fora where we could settle our dispute, where we could litigate, where we could go on and contest certain claims. Now, there we started developing these formal laws. But the nature of these formal laws were according to the culture of the country in which it was being formulated. And you will be agreeing with me that the nature of the law, what we see in India, is different from what you see among the SAARC countries, the nearest example, and also to Britain, UK, Australia, Africa. The nature of the law changes according to the culture and custom that were prevalent in that country. But there is another group of thinkers who said all this is not necessary. What is important is law is what the court thinks it is, the lawyer pleads it is, and the judge understands it to be. Therefore, law is a game which is played out into the field of litigation. They say that when the parliament or the legislation is promulgating a law, they are making an abstract law in abstracto. It is general. It is not meant for a specific situation or a specific context. But when the facts come before the court and the court uses the law to understand the fact and give out justice, it is the role of the lawyer as how he presents the facts and interprets the law according to the fact and in his favor, and how the judge appreciates the argument on both sides, whether it is the petitioner or the defendant appreciates the facts and the interpretation of law on both sides, and depending on the evidence which establishes the fact, the judge goes on to give a judgment, and his interpretation is the actual law, binding on the parties and binding on the others. But you must remember, and this is very important to remember, that each judge may differ, and therefore there will not be any certainty and consistency in the making of judicial interpretations. Therefore, there is a system called precedent. In India, the Constitution says the judgment given by the Supreme Court is binding on the High Court and all other courts. But the judgment given by the High Court of a state is binding on the lower court of that state. What does it mean? It means that there should be consistency. In similar situation, in similar cases, the people should have similar kind of justice meted out. So there is this system of precedent. The Supreme Court is not bound by its own precedent, it can change. But the High Court is bound by its own precedent. But it may change if the case is distinguishable. Therefore, a law, as I said at the outset, is an open concept. Law is wide, interesting, and it can take in within its concept, it can take in many things. So I hope you have understood what is law and why we need law. Thank you.